So you've presented the court with the critical machining alternative, and you say you have these two alternatives. The agency has presented yet another way of going about this. Do you concede that under a facial challenge like the one that you've brought, your task is actually to demonstrate that your alternatives are the only permissible ones under the statute?
Well, I think it's under a rule of party presentation. We've presented the court with the alternatives that have occurred to anyone. So I think these are the best alternatives that have occurred.
So you see the question as what is the best alternative? And the court is just supposed to say, we have three options here. Which one do we think the best? The agency didn't pick the best. It's rule stricken.
Well, I think we actually don't have that. I think our burden is to show that the agency's is wrong. Maybe we don't have the right interpretation. But if their interpretation is incorrect, then they're asking the wrong question.
But by incorrect, you mean that they don't have the authority under the statute to reach that? It's inconsistent with the statute?
Correct. If frame or receiver does not include items that may readily be converted to frames or receivers, then this rule is beyond their authority, regardless of what frame or receiver does mean. So they've gone beyond their authority. And so, we've presented the courts with two alternatives that we think are better interpretations. But the key point here is that the agency's interpretation is incorrect.
Do you believe that a weapon that has been disassembled, a firearm, a gun that was once fully operational, everyone would agree was a firearm, it's disassembled, as sometimes happens, maybe even after a crime, is that still a firearm or no? Under your view?
Yes, and for two reasons,
okay.
If I could give it. So the first reason is that we'll have a frame or receiver. So that's what Congress put in the statute to ensure that would be a firearm.
Frame or receiver is not in the box.
Oh, then no. If you don't have the frame or receiver, then no, it's not a weapon.
So all that matters really is B, the frame or receiver.
Well, that is how the statute is structured, and part of that may be due to statutory history. So before this statute, the definition was any weapon that is designed to expel a projectile by the action of an explosive in any part or parts of any such weapon. And I think we.
But what's all that language doing in there if all that matters for the purpose of the definition is that it has a frame or receiver?
Well, and so what I was going to say, Your Honor, is that Congress was working from that background, and they said, okay, we're going to alter the definition of A to include readily convertible weapons, and we're going to alter the definition of B instead of including every part to focus on a particular part, the frame or receiver, and it's the frame or receiver of any such weapon. So it really could, so I think that explains, that's why it's structured that way. It's maybe not the most straightforwardly structured statute, but it could be the frame or receiver of, and then insert A instead of any such weapon. That's really how the statute is structured.